well, let me stop sharing and let's have a talk about the assignment. Because I understand that there is a bit of stress going on out there. And I'm sorry if I sounded cranky with my post on Facebook, Sarah. I did not mean to be cranky at all. I was...
It was for me, but for everyone.
I understand. And I was really shocked that argument was still going on, because I heard that it was going on by the mentors, and I couldn't for the life of me understand how there was any lingering uncertainty. So for those that aren't aware, there was this big kerfuffle about whether the assignment required you to in any way discuss any legislation. And I thought I had been more than abundantly clear on the point by saying, do not discuss statutory unconscionable conduct. Do not discuss anything other than duress. And some people still seem to want to discuss that in their assignment. And I've said, absolutely don't. So if anyone's listening to this later on and you're still unclear, please don't discuss statutory forms of duress or unconscionable conduct, or extortion under the criminal code I've had people bring up, or anything like that, please, because this is such a small word count. You will really crucially rob yourself of the words that you need to actually get across the line in terms of applying the case law that you need to apply. Okay, so don't make that mistake. I had somebody else ask me, you know, the Barbatus case seems to go against us. You know, what do I do? Do I just say, well, do I explain that I know what the Barbatus case was about and say, sorry? No, please don't do that. What do you do if a case seems to go against your client? Do you just give up? What do you do logically? Tell me some strategies. Open a discussion with me, people.
Tell them the truth.
Tell them the truth. You can't handle the truth.
I think that's our job, isn't it? Is to advise on where they stand with that particular part of the law, and if they don't have good standing, they don't have good standing. I think, isn't that the point?
Yeah. Well, what happened?
Sorry, AJ.
Yeah.
Have you turned off recording?
No, I haven't. No. The people at home, I've had several people that needed to leave early and wanted to see this part of our discussion this evening. So if you want to say something inappropriate, maybe...
No. Evil, I was thinking of, not inappropriate. Evil.
That's fine. You can say it to me after. Routinely, as a barrister, lawyer, even as a judge, if you have an inconvenient case that stands in your way, think back to Intro to Law, think back to Contract A. What do you do about it? How do you get around it? One word, starts with a D.
Discuss.
You give information to the Victorian Police illegally. Oh, people still have their sense of humour. You distinguish. What does the process of distinguishing a case involve, people? This is laws 11057 stuff. This is laws 11061 stuff. Basic, basic, basic. What do you do if you've got a case standing in your way? How do you distinguish a case?
You differentiate the facts.
Yes, you distinguish the facts. What does that involve, Keith?
Well, knowing the cases and drawing on the detail.
Yes! Thank you. Thank you, thank you, thank you. I didn't, yes, Tyler says Iraq. Yes. So in your application section, this is where you are going to be explaining your position. Okay, I didn't realise, and forgive me, I do apologise, I didn't realise that people were still struggling with these basic fundamental concepts. But that is what you do if a case is standing in your client's way. You have to know every element of that case, every fine detail of the facts. And then, because what's the whole, go back to laws 11057 intro. What's the whole basis of stare decisis? When is a court actually bound by precedent? It's only ever bound by precedent if the facts are sufficiently similar, isn't it?
Well,
So
ultimately, yeah.
therein lies the game. Therein lies where lawyers get their billable hours. Okay? You need to be able to then look at a case that's inconvenient and try and pull it apart and try and get enough doubt into the court's mind about whether they should go down that same path. Okay? Right from the very moment when you hit Carlil and the carbolic smoke ball case in contract A, you even say, the court even says in that case that you strike almost as case number 1 in contract A. Even in that case, you see the court looking at a reward case that was inconvenient and distinguishing it. They say, well, hang on a minute, that doesn't actually bind us here because in that case, well, it wasn't really all about the issue that we're discussing here. It was about privity. So we're not bound by that case. Are these concepts ringing bells for you guys?
No, it's just showing a difference to the real world, which is outcomes focused, not process focused. This is a process approach.
I'm going to leave that to another day, Keith, because again, we need to be talking about the assignment.
Yeah, that's fine.
Given that it's late in the day, and I understand your frustration with the fact that, you know, the law is not as you would like it to be. But inevitably, much of the law is process focused because decisions have to be made according to a process in order to be reliable as an outcome.
But the outcomes aren't reliable, so I'll talk to you later.
By and large, I understand that's a critical legal studies approach, but by and large, you know what, the common law system operates reasonably well. Sure, it's on some levels a game. Sure, there are good ways to distinguish cases. But the principle at bottom, I think, is sound, and that is that if a case is similar enough to another case, it should be followed. If it's not, then it should not be followed. Now, of course, we're dealing with words and ideas, and all these things are malleable. So there's got to be a malleability attached to all of this. It can't be 1 + 1 = 2. But by and large, I think our common law system does pretty well. Call me an idealist.
It has served well over the years, and there's no argument about that. And you're coming at it from a particular point of view, but you're coming at it from a participant inside the system, not outside the system, whereas I'm coming at it from a participant outside the system looking in.
Yes. Okay.
And any system that costs me a minimum of $60,000 to enforce any one of my rights, and where the outcome is potentially variable, is possibly a problem to me. And when I see some of the outcomes here, where we have a driller who, poor driller, he never meant for that to happen, as opposed to somebody else who buys a car, but buys the car from someone who doesn't have title. It's not the innocent party that pays the price that time. Sorry, it's not the innocent party who gets protected that time. It's the guy on the pass through.
Occasionally, you will get the end party being protected. It just depends on. Generally speaking, in terms of your car scenario, the end party will be protected. It's the interim part. It's the original seller that's going to be.
Or not in the case of someone who buys a stolen car, unless they buy it from a dealer, and then there's all sorts of statutory stuff surrounding that. But the common law says that you can't pass on title that you don't have. So you go and buy a car privately in good faith, and suddenly the car is under finance or stolen. And unless you've done the checks, unless you've done blah, 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 then it's your problem. Our driller, it's not his problem, but he's in the business. That's what I guess where I fall over. Somebody who buys a car because they do it once every 5 years, 3 years, and as opposed to a driller who is doing this for a business, but the driller is to be protected and the car buyer isn't. But that I have a problem with.
These are the things that the courts struggle with, though. I mean, even in the car scenario, you've got a variability in some of the outcomes there, where some of the courts have said it's voidable. And so, I mean, Denning is a classic. In that scenario, he held the contract voidable, not void, and therefore the end party was protected. So let's defer this discussion because it's getting late, and I want to make sure that everyone has effectively had an opportunity to. I don't mean to be rude. I just want to kind of move the discussion on, if it's okay.
All good, AJ. All good. All good.
I understand there are lots of philosophical burning questions, but other people, Tyler's saying, can I ask how many references would you expect us to have in our assignment? Is quality rather than quantity more important? Yes, definitely quality rather than quantity is important. If you do have a problem with your word count, I would suggest moving some of your discussion to your footnotes, because your footnotes do not count as part of your word count in my units. They don't count. Some people have said to me, why not? And I consider that you shouldn't really be penalised for having to cite the cases. By penalised, I mean, I don't see that citing the cases in the footnotes should count towards the words that you are telling me are the reasons for you, deciding one way or another for the client. And you've got to have them in there, and I don't see why they should count. That's why, I say if you have an issue, then put it in the footnotes. But by the same token, I don't want to see another 2,000 words in the footnotes. And I did have a student give me almost 5,000 words in their total assignment. And in that scenario, I did rule a line and not read anymore, but please use your discretion. Don't abuse the footnote process. But if you do feel like there are things that you need to say, then hive it off to the footnotes. I'm happy for that to happen. In terms of how many references, I'm a little concerned about that because so you will need to necessarily have a footnote for each of the cases that you cite, obviously. You would have done that hopefully for contract A. So you're familiar with the Australian Guide to Legal Citation, I gather, because I think we've had discussions about that before, haven't we? Please tell me 1 for yes, 2 for no. 1 for yes. Okay, good. So you know that you'll need to cite your cases. So in terms of how many references, it depends on how many cases that you bring into your discussion. And obviously, okay, no worries, Nicole. It's going to be recorded anyway. So make sure that you do follow AGL. 2,000 words equals at least 40 footnotes. I don't have a rule of thumb, but yeah, you will need a few, I would say. Oh, look, there's 3 thumbs, Shona. So other queries. You know what? I often have students forgetting punctuation in their footnotes. Why does this happen? Footnotes need punctuation. Keith's up to that already. I know. Oh, well, I don't mind how many footnotes you have. It's, if you're signing cases often.
What you're really being asked is how many cases do you expect us to reference? I mean, you've got Amadio, you've got Bartis, you've got probably a couple of others. You've got probably News Corp. You've got the Hyundai case.
Wow. Why would you be citing Hyundai? Oh, you're talking about economic
Duress and delay.
Yes. Mm-hmm.
As person, then so is News Corp.
Yeah. Okay. Mm-hmm.
So being kind of us trying to bend over backwards and meet your requirements, that's what you're really being asked.
What? Okay. Oh, wow. I'm just...
And okay, maybe you can't tell us. Maybe you can only give us some broad guidelines. That's fine. I'm sorry, I don't mean to put you on the spot.
So what case did I tell you to read for the duress part of things, Keith?
Yeah, you did. Sorry, gone out of the head. But I have read the bloody thing. That's what peeing me off.
Yes, Barton. And what case?
Yeah, Barton and Armstrong.
Yes. And what case did I tell you to read for the unconscionable conduct part of things?
Barbados.
Yes. So if you don't cite both of those, what will happen?
Naughty corner.
Your prospects of passing the assignment will be rapidly diminishing. Okay, where a lecturer points you in the direction of certain cases, then you must necessarily go down that track of pursuing those cases and cases of that ilk.
Well, we're going to do those by default because you asked us to do them, and you did specifically ask us to do them.
In what font? Sorry?
And anything other than the font that you want to do it in. It doesn't matter to you, I don't think.
Doesn't matter. No, it doesn't matter. It's the referencing back to every time you refer to the case adds to the footnote count. Yeah, I know. And that's the reason why I don't count them, Shona. I don't think it's fair because 2,000 words, you know, it sounds like my 13-year-old the other day said to me, 2,000 words. How do you use up 2,000 words? And I'm like, wow. You know, when you're a law student, you're like, oh my gosh, I'm already at 2,000 words. You know, and then you've got to go through that laborious editing process. So I don't like to penalise people in that direction. Quite quickly, I know. Other queries? Please do make sure you discuss Barton and you discuss Herbaceous. What was the nature of the threat in Barton?
Murder.
Yes.
Physical harm.
Yes, and what was the nature of the threat in the assignment?
Well, it was purported physical harm, but it was a plastic gun in a pocket, but that it would have been perceived as physical harm, so it's physical harm. It's what's perceived in the eyes of the receiver, not the protagonist.
Yes, yes. And what was the damage in Hyundai?
Hyundai was, the problem was they left it too long to actually make the claim. And on a couple of their payments, they apparently didn't say this is a payment under default, under protest.
Yes, but what was the nature of the threat?
Oh, you won't get your ship.
Yes, so what was the nature of the threat at bottom?
Duress of goods.
Yes, but what was the nature of the threat at bottom? It wasn't physical harm.
No, it wasn't physical harm. Sorry, it was property harm for goods, harm for property.
Economic.
Economic. Oh, okay. Yeah.
So I'll leave you to ponder that.
Oh.
Okay.
I got that. Yep, thank you.
I take that point that there was an issue of delay. I take the point that there was an issue of delay.
Mm-hmm.
But where I have specifically said to you, look at Barton, right? I expect you to discuss Barton in the context of that question.
No, Barton's fine. Hyundai lost. Sorry, North Shipping lost.
And you're saying it conveniently discussed issues of delay?
Delay, yeah.
I have no problem with that.
Okay. Yeah, no, that's fine.
I have issues with trying to default to an economic duress argument. Okay?
Okay, gotcha.
So my only Sarah's looking
My answer and everything in here. I understand where you're coming from now. It makes clear.
Well, why would I instruct you to read Barton?
Right. Well, because it's so close to our case. And
yes.
We follow that the similarities are so close. So you want us to obviously follow the case, but it doesn't. We need the other cases to support our conclusion. Hence.
Have you read every word of Barton?
I believe so, but I will read it again.
Yeah, where a lecturer, put it this way, do not overthink this. Okay? Do not overthink it. Where a lecturer says, read some cases, go away, do your best, and come back to me. I'm not saying don't look at other cases. I am saying be principally guided by the cases that the lecturer says to you be guided by.
Which is fine, except that we've been ambushed in the past where lecturers have said, read case A, B and C, and then you put the answer in and they say, you forgot about D.
Well, and this is something that I've specifically said to Sarah on Facebook. I personally, I know that there are some lecturers that do assessment by ambush. I don't do assessment by ambush. I am not saying that these two cases are the only cases that matter, but I am saying if you don't discuss these cases, you seriously prejudice your ability to pass this assessment. And if you don't know every little bit and piece of the facts in those cases, then it will be a problem for you.
No, we'll certainly know those.
So, and where I guess the ability to impress me in terms of your mastery comes is where you do decide to bring in other cases, that you select cases that do have principles that assist your conclusion and are relevant. And as long as you've satisfied those two criteria, then, you know, you should hopefully be in a relatively safe place. Okay.
El Crescendo, for example, where you have a and yeah, I know it's on duress, it's not on unconscionable conduct, but the two are so close together it's not funny, and the principles carry across, and there you start. They've brought in a new principle where the pressure is now not just pressure; it's whether it's a legitimate pressure.
Yes, although you have to be careful of that.
Okay, it was called repeal in New South Wales, wasn't my fault.
I'm just going back here. So, I don't really want to get bogged down in a discussion of individual cases because this is not an exercise in providing you with the answer.
No, that's fine.
And I'm just wary of, you know, providing too much in the way of individual guidance on how you should be interpreting the. Here we are.
Okay, but that's fine. Don't. It's a comment. Treat it as a comment, not a question.
Again, what was the basis of, what I will say is this, what was the, I can't find it in the text now, but what was the kind of duress at issue in Crescendo?
Crescendo was the same type of duress as in Amadia, except Westpac were demanding that they withhold funds and pay off other mortgages rather than the funds from a particular mortgage be distributed to the parties. The court held that...
I don't need you to tell me the facts. I know the facts of the case. What was the kind of duress?
Oh, sorry. My apologies.
What was the kind of duress?
Economic.
Yes. And what is the kind of duress here?
Duress.
What kind of threat?
Are you talking about in part two of the question? It's obviously physical.
Yes.
But I wouldn't have thought this came under the physical. I wouldn't have thought this was relevant to the second part of the question.
In terms, I haven't got the question in front of me, but where I ask you to discuss duress, what kind of threat is made?
Well, it's a physical threat. But the principle behind duress, all of this stuff has a common theme.
Okay, I'm not going to discuss any more on that, Keith. I'm not going to debate it, and I'm not going to discuss it because I can't. There is a risk that I will start giving guidance that I probably shouldn't give.
No, that's fine. I understand your position, and I'm not trying to take you across that line. I'm sorry. I don't mean to do that.
Sure. I just want to, I'm trying to give you a nudge, and that's about as nudgy as I can get.
You have. I've taken the nudge.
Okay.
And unfortunately, I've nudged back, which is.
I've given the nudge twice, so I'm hoping that you'll take the bait. And this is why I say, please don't overthink things. AJ wants us to go down that reread button.
Well, you read his button. Trust me.
I'm just reading the comment box here. North Ocean can be applied not because it's economic duress. Well, why would you want to argue it as applying in terms of being economic duress when it's just, anyway, I don't think AJ wants us to go down that route. Just think simple, folks. Think simple. Simple.
AJ, sorry, can I ask a question? Sitting here patiently. Actually, firstly, thank you for your feedback on an IRAC I wrote the other week, because believe it or not, you're the first person to give me feedback on my referencing.
Oh, really?
And I've just started my second year, so that's a little bit concerning, but I've gone back to my HLC book and been relearning how to do that properly in the last week, so thank you. And I'm glad that came about before I handed in my assessment. My question, though, is that going back to a comment made earlier, that the case you've asked us to read goes against our client. But the purpose of the question is to advise our client on their prospects. Am I correct? So it may be that we're going to argue that they would or would not be successful. It's not our job to find a way to make them successful. Does that make sense, my question?
Yes, don't ever overstretch things. If you can distinguish something, distinguish it. But of course, you would have to say to your client, there is this case, it may be problematic, but then, we may be able to get around it by doing ABC, XYZ, arguing this, arguing that.
Yeah, okay, great. Thank you. That makes me feel like I'm on the right track.
That comes, obviously, that comes with inherent risks, obviously, and that factors into then normally a client will want to hear comforting words in your advice that give them some feeling of guidance. So I'm talking about in real life here. So in real life, you need to say, look, there is this case. It seems to go against us. However, and given that it seems to go against us, look, we think your prospects are, reasonable at best, or modest at best, or poor. Or conversely, you might say, look, we are very confident that we can sufficiently distinguish this case because, X, Y, Z, ABC. So it factors into the nature of your discussions with your client and their ultimate decision. Again, this has nothing to do with this time. I'm just talking about in real life. It factors into their decision as to whether or not they press go and spending a lot of their cash to litigate or how, the strategy that you advise them to take. You might say to them, look, we'd be happy to do a couple of letters of demand for you, but I don't think you should throw away any more on this than that. So it will factor into the nature of the discussions that you have. But you certainly don't just give up the ghost. And even where a case really would stand in your client's way directly and there's no way to distinguish it, that doesn't stop you from having to go anyway in real life and writing a letter of demand and just seeing what reaction you get. I've had the case where people just roll over and go, oh, a letter on solicitor's letterhead. Oh my gosh, where do I sign? How do I pay?
I think that might be where I've been going wrong, because I'm thinking advise them of the question in front of me. Advise them if they may avoid the lease on the basis of unconscionable conduct, and straight away I'm going, how are we going to argue this in court? But we should be thinking of those other options, like you said, then, of the letter of demand or mediation or other ways to get a result.
I'm not talking about, when I talk about that stuff, I'm not talking, please let me be clear, I am not talking about the assignment when I talk about that stuff. And please don't start giving me stuff in the assignment that talks about mediation or practical solutions, please. This is a purely artificial construct that we are dealing with here called a first-year law school piece of assessment. And these beasties are designed to flesh out for me how well or how poorly you understand the two simple, or not so simple, concepts I have asked you to address, which are duress and unconscionable conduct. That's it. Okay. If you really wanted to advise your client, you'd need about 5,000 words in real life. So please don't go wandering off into things you don't need to be wasting your word count on. All right. You need to be looking at the case law that I've asked you to look at. If you want to throw in other case law, remember the two criteria it has to fit through. It has to be relevant and it has to support your argument. Okay? If it passes the smell test, throw in other cases, and I will expect that you probably should throw in other cases. Okay?
But the next relevant case is Sampton, and that doesn't support the case either.
I'm sorry?
The next relevant case is Sampton, ACCC versus Sampton. It's a pre-Anne Sampton, I should say.
Hmm.
And that was decided by the full federal court in Western Australia, and that doesn't support our case either.
And?
Well, that just happens to be the next relevant case. There's one that was in New South Wales Court of Appeal, I think it was. Kemenis?
Keith, I don't want you to be disclosing all of your research here. I don't think that's appropriate, and I don't want to go into the merits of your research or otherwise, okay? I don't want to wander into that area, because that really does put me in a difficult position, because what you're essentially asking me to say is, yes, that's relevant, no, it's relevant, not relevant, and I can't be doing that.
No, that's okay. I understand, and I'm not trying to put you on the spot. I'm just trying to participate in the discussion.
Oh, okay, that's fine. But if you're saying that you believe that your client has a poor case, well, that's your view.
Okay.
And that's what you'll write on your piece of paper, and that is what I will mark. Others may have a different view.
Yeah, got that.
And I will also mark all of those. Okay, so it's up to you to convince me that your view is correct.
Okay.
And that is all that, you know, any legal argument is designed to do.
Okay.
Is designed to persuade and convince. That's what it comes down to. As I said, you know, that I'm reminded of the lovely barrister lecturer that I had in London, and, you know, acting as a junior to a famous barrister in London, and, you know, he got up and made that brilliant exposition about what he thought was his client's case, and then he was told that he was actually making arguments for the other side, and then shot them all down. I mean, that's the nature of law right there. You know, it's about persuasion.
Yeah, no, I've got that. It's all about words and the ability with your English language, based on a few concepts. No issue with that.
Hmm. So, you know, often in an assignment, not often, but in assignments, I never close off my mind completely to any student's argument, because it's not ever a 1 + 1 = 2 kind of equation. It's always shades of grey. There are some answers that are more correct than others, but it's very rare that an answer will bear no merit whatsoever. So, well, I have to say I have had a few of those in my time as well, but generally speaking, you can't close off your mind to one view. So I've done my answer guide. I have a view. But I'm certainly receptive to persuasion.
It comes down to entertainment.
Yes, it does. Keeping the lecturer amused.
Toddler, our lecturer, I think it was in the guide, wasn't it?
I know, that's me. Very short attention span. Alison, Lena, Tyler, Christine, and David, are there any other questions? Because I'm mindful that it's past 9, which means it's past 10 in some of you guys' parts of the world. So is there anything else that you would like to touch base on while you've got me captive? No. Someone just left. I think that's a signal. Of Alison says no. Thank you, Alison. Lena says no. Okay. So Tyler, are you all good? And Christine, Tyler's all good. Okay. And Christine, I'm hoping you're all good. I just don't want to leave before I've given everybody an opportunity to say stuff. Sweet. No problems. Okay. Well, it's obviously not Friday yet. So if you have other queries or questions, please let me know. That's okay. And just shoot me something, preferably in the either on Facey or on the Moodle forum, so that everybody gets the benefit of your questions. Because it's funny, I think a lot of people are nervous asking questions in a public forum, but it's amazing how many questions I've got, like all of the same nature. It's quite hilarious. Like often I'll get a run of, I just want to check that word count isn't affected by your footnotes. Your footnotes don't count towards your word count. I'll get like 6 or 8 emails all saying the same thing. So please, I'm sure that there are other people that have the same kinds of questions. So just post them up to Moodle, and then everyone gets the benefit of them. Otherwise, I'll just de-identify them and post them up. Any other questions?
The only ones on statutory versus equitable remedy. Equitable principles, given that the Barbados case was decided before 51AC was implemented.
Okay, this has brought us full circle.
Yeah, I know you don't want us to go there, and I haven't gone there. I'm not gone there. That's an intellectual question, not an assignment question.
Okay. So you're saying if this was real life, would you run it under statutory?
Well, yeah. I mean, it just seems so. You'd be in the ACL section 22, which is the equivalent of the TPC section 51 AC. There's no way known that you'd be running it just under AA or under 20.
That is a whole nother conversation. Generally speaking, it's not a matter of, and this is a litigation tactic, generally speaking, what I might do is just stop the recording here.
That's a good idea. Yeah.
Bye, folks. To put everyone out of their misery that doesn't need to listen. Bye, guys.